Thank you for being here. Appreciate it. And we thank you for being at ISRI Convention, and we hope it's been a good couple of days for you so far. My name is Adina Renee Adler. I'm Senior Director for Government Relations and International Affairs with ISRI, responsible for working on behalf of our members who are doing business all over the world, advocating in capitals, both in Washington and around the world, and trying to help you facilitate the movement of your materials across borders. Just before we get started, if you were here earlier, you'll hear this spiel again, so if you can bear with me, just a friendly reminder to turn off your cell phone ringer, just to be respectful to your neighbors and to us up here. Can be sort of, and it's of course happened anyway in some of our sessions, but if you don't mind just doing that, it would be great. And of course, if you need to have your phone rings and you need to have a conversation, if you don't mind just stepping outside to have that conversation. We don't want to keep you from networking, which of course is the reason you're here. If you're not a member of ISRI, there's plenty that we do on your behalf. We have education resources. We help out with safety. We are updating specifications of certain materials. And then on the advocacy thing, as I said, we're here to be your support if you're having any concerns or seeing a regulation either in the U.S. or somewhere else in the world that is troubling. You can certainly come to us and we help you out. So we're sort of a full service for our membership. But of course, one of the ways that we help our members is to put on these workshops on lots of different topics, and I'm sure you're an information overload, but I think this is a topic we haven't seen too much yet at ISRI Convention yet this week, which is doing business in Mexico, how to do it, and then sort of things that are going to be popping up within Mexico. But we will of course comment on the North America Free Trade Agreement too, because that's just a very important part, I think, of that market. We're going to do a little bit of a different structure than maybe you have seen in some of your other workshops. Carrie and I are going to kind of tag team a little bit. She's going to do the majority of the speaking, and these are her slides. But there is going to be a moment where I'm going to pop in and talk a little bit about NAFTA, and then we're going to. I may have a couple of questions that I'm going to ask of her to speak on, and then we'll open it up to the audience. So just to shake it up a little bit on that structure. But let me introduce Carrie Kroll-McMullen. She is with the law and consulting firm Venable in Washington. And she has a lot of experience working with her clients on all facets of exporting from the United States as well as importing into the United States, including on export controls, economic sanctions, inward investment, free trade agreements, customs, anything that is captured by the word trade. I think Carrie touches that in her work. And she also advises nonprofits, including ISRI and associations, on practical how to do business requirements in the United States and around the world, which is why we asked her to come talk on Mexico. So as I said, she's going to do most of the speaking, but I'm going to pop in as well. We will have a little bit of a conversation, and then we'll open up to question and answers. So Carrie, I turn it over to you.
Great. Thank you so much for that introduction, and good afternoon, everyone. Thank you for joining us here today. As Adina said, my name is Carrie, and I've been practicing international trade law for about 10 years. And in doing so, have had, also as Adina said, a lot of experience working with U.S. clients as well as non-U.S. clients in doing business in Mexico, taking advantage of free trade agreements, navigating customs issues as well as export control issues, both on the dual use or commercial side as well as the defense side. We also do a lot of work for our clients in looking at anti-bribery considerations and anti-corruption considerations, which are definitely part of what you need to look at when you're doing work outside the United States. And so taking all of those sort of lessons learned, and in addition, the focus lately, especially under the new Trump administration, on trade and trade issues, this topic was super interesting to me, and to talk with you and your industry about today. Mexico is a longtime partner and a neighbor of the United States, so there are lots of opportunities, and with those come the challenges. We're going to talk through 10 considerations to look at in the Mexican market today, and breaking those out into sort of 3 big categories, which are business, cultural, and legal. And then we're going to talk through 2 case studies, which are actually based on work that I've been specifically involved in over the last few years. And then we look forward to any questions that you might have. And so starting out, and it was sort of interesting when I was first asked by ISRI to speak about this back in December, I thought, oh my gosh, I'm not sure that anything that is true today would be true on April 26th. And so I hesitated even putting anything down in writing here. But I think that, and even waking up this morning, the news headlines had some updates on what we might be seeing in the next few days, the last of the 100 first days of the Trump administration regarding NAFTA. And we'll talk a little bit more in detail about that in a little bit. But, you know, despite the long-term relationship between the United States and Mexico, we are seeing an evolution of that today. That said, I think the biggest takeaway to understand as we're all sitting here is that nothing has changed yet insofar as the legal structure and overview that U.S. persons and U.S. businesses are expected to operate under. The regulations haven't changed, NAFTA hasn't changed, export controls have not yet changed. We expect that they might, but sitting here today, they haven't. And so we really can talk about all of these issues and considerations like we have, and learn from what we have seen over the years. And so starting out, Trump administration proposals, he has talked about tariffs on up to 35% on imports from Mexico and a complete withdrawal from NAFTA. We put that in the unlikely category, and I think that's probably still true sitting here. We have a hotly debated category, the border adjustment tax, which is something that actually has existed for many years, but has not been consistently enforced over the last couple administrations. What has been proposed is an enforcement and a withdrawal of what's called a waiver provision on the border adjustment tax, so it would add to the capital value on imports. That, again, has not happened, so it's something to keep in mind. And as we said, we're not putting it quite in the unlikely category. And finally, in our likely category, renegotiation of NAFTA. This is something that we think we're going to see, and today's news was an announcement by the Trump administration that we might see an executive order in the next few days announcing withdrawal from NAFTA. In actuality, all that does is trigger the negotiation discussions that would need to take place before any formal withdrawal. So it sounds a bit more robust than it is. And then we know that the Mexican government over the last decade or so has also worked to seal certain bilateral and multilateral trade agreements, robust ones, in fact, throughout Central America and South America, as well as with our EU trading partners. And so to the extent that any of you sitting here today have existing businesses in Mexico or are looking to open, an actual legal entity in Mexico, there are free trade agreements that local Mexican counsel can really assist you with. So the next slide, we just go through, and I'm not going to go through each of these in detail now, but these are, I sort of put them in the top 10 category of considerations when you're looking at any international market. And here we will focus our discussions on Mexico. I am a U.S. attorney, and so I am looking at the U.S. legal issues that are presented to our clients day in, day out. And these apply no matter where you're doing business. But every jurisdiction has its challenges. And one of the things that we always say right out of the gate is, looking at the U.S. legal issues is one side of the coin, and then looking at the Mexican legal issues or whatever jurisdiction you're looking to explore is the other. And looking to secure a good relationship, one that's transparent and reliable with local counsel is often a great way, or not necessarily legal counsel, but at least a consultant to dip your toe in the water and start that process. We'll talk a little bit about both sides of that coin today with a focus on the U.S. side. Okay. All right. So our next slide, We're going to start with talking about what are your goals in the foreign market. And so by your presence here today, we would assume that you're looking to do business in Mexico, potentially explore opportunities there, or grow or shift the way that you're already doing business there. And there are lots of opportunities and lots of ways to do that. We share a border. There are various free trade agreements in place, as well as opportunities through the Maquiladora inbound processing and inbound processing companies that we can talk about as well. And so identifying what your goals are in the foreign market, almost every time we speak to a client in the first instance, that's what I say. What do you want to do there? Do you want to increase your brand presence? Do you want to set up a relationship with a distributor? Do you want to look to take advantage of less expensive labor opportunities or manufacturing expertise? Do you want to partner regarding a technological or technology opportunity so that you'd be sharing data or IP over the border? What are you trying to do there? So identifying that concretely is really the first priority. For-profit and nonprofit entities, there are various opportunities that range in how much capital and sort of on-the-ground activity you would be expected to have in Mexico, and we'll talk through those. And whether your goals are long or short term. We hear a lot about like green technology initiatives. Is there something that in the short term you'd like to take advantage of, either under U.S. or Mexican laws and regulations? Is there a huge trade show you'd like to be part of and you'd like to have a Mexican presence in advance of that? Or is this really about growing, your North American business in the long term? Would you like to do it partnering with an entity there or independently? And who is that partner? We're going to talk a little bit about that later as well. And we already discussed what are the activities? What are you looking to do? Sales, distribution? Is it more about setting up something in brick and mortar? And so, does Mexico make sense? This is the next question I often talk to my clients about. Again, is it a one-time event or is it establishing a presence? This is the threshold question. Every country around the world has variations of what we call registration or quote-unquote doing business requirements. And so identifying in your jurisdiction here in Mexico what those are and when they would be triggered is a very important consideration. Is working with an agent in Mexico sufficient to trigger doing business requirements there? And what are those doing business requirements? And just to give you an example, oftentimes the answer is it depends, which I know is a very lawyerly answer, but one that really rings true. Working with an agent where you don't really have any boots on the ground from your entity here in the U.S., who maybe dedicates a couple hours a week to identifying opportunities for sales or distribution in Mexico, probably would not raise to the doing business threshold requirements. But on the other hand, engaging with someone long term, entering into a contract with them where they may be an independent contractor but nonetheless may only be working for your entity, even if you don't have any of your own people down in Mexico, that may be enough to trigger the doing business requirements. And then what are those? Are there registrations with the tax authorities? The answer would be yes. Do you have to pay into any sort of Social Security or employment funds? And the answer would be it depends again, but that may hold true depending on the relationship with your agent. And so all of those are important to consider. So is there a tax treaty in place? Here we've got the overlay of, yes, there is a tax treaty. In addition, NAFTA and the free trade agreement benefits that you can take advantage of. And then with respect to Mexico or any other jurisdiction that you're considering, are there repatriation issues? This has come up a lot in the business that I've done where there may be money that's profit based on sales or opportunities, services in the foreign jurisdiction, and there may be restrictions on what amount or percentage of the money can be repatriated or brought back into the United States. and whether and how that money is taxed once it leaves the country. Those are all things to consider. Is the jurisdiction you're looking at a stable one? Does it have a stable government? Is there crime? Is there potential security or safety issues? Mexico has an extremely stable government. We all know about some of the crime and safety concerns that have come up over the years. They really vary by region. But there is an elected government that changes through a democratic process. That's a great thing to know about a jurisdiction where you're considering doing business. We call that the rule of law test. Are there foreign investment rules that are either beneficial or may hinder what you are looking to do there? In Mexico, a great resource is the National Commission on Foreign Investment. It's under the Ministry of Economy. And there are certain foreign investment rules that are, frankly, very beneficial to certain kinds of entities and businesses in looking to invest in Mexico. And so seeking out those resources and making sure you take advantage of those before just kind of jumping in is often very helpful. And then what are the U.S. export controls on the country, on first of all, your product, whatever variation of the scrap metal and recycling industry you may be working in, on your product leaving the United States and your product going to its destination. Despite the fact that Mexico is a close neighbor, an ally of the United States, we actually do maintain fairly strict export controls on certain products leaving the United States heading to Mexico. And whether and how those apply really depends on what your product is, who the end user is, and we'll talk about that a little bit more later as well. Are there sanctions? Again, we'll speak to this later, but that is, can you do business with persons in this country and entities? Can you provide services? And are there any restrictions on doing so? And then we already talked about the export initiatives and the benefits that you would get from certain trade agreements like NAFTA. And so we always say a phased approach is one that is recommended. And I think I already said dip your toe in the water first. It's something that we often recommend. Unfortunately, it's typically easier to enter a market and enter a new relationship, start up a new opportunity than it is to unwind it and get out of it. And it might be the most successful thing in the world, and that would be fantastic. But in the event that it's not, we always want to caution and talk through what is the best way to look at the opportunity, to think about the due diligence that you're conducting, both on the market, as well as the partners, as well as the sales opportunities, et cetera. And so if there's no Mexican presence already for your company or your entity, we talk about considering participating in an event, having a presence at a conference like ISRI's, hosting a networking event with a similar company, or partnering through an agent or a consultant. With respect to in the nonprofit world, we've seen a lot of success in this regard where companies, nonprofit entities have looked to partner with similarly situated nonprofits or trade associations. And in your industry, there is ample opportunity to look at resources like that, both private and public, government funded and outside the government, and determining whether there might be opportunities there to say, let's put on an event together, show that you sort of have a foot in the door. And we often find that the market opens up when you are sort of considered a local. And that's very true in Mexico, where relationships are very important. And then options for separately incorporated entities. In Mexico, joint ventures are often a very popular opportunity for U.S. entities. We are right over the border, and so looking at joint venture partners, conducting careful due diligence on them, and then determining what level of investment in a joint venture might make sense. Investing in a local entity, including in a maquiladora, may also be a prudent way to enter the market. Based on whether your company here in the U.S. is conducting further manufacturing, either here in the U.S. on collected resources or in a foreign country, Mexico's maquiladora system provides a really nice opportunity for that, especially with careful NAFTA analysis, where oftentimes goods can leave undergo further processing and come back into the United States duty-free. And that's a careful analysis that's fact-specific, but one that can include cost savings both from a labor and a duties and tax perspective. And obviously, establishing a full separate corporation in Mexico would be the final opportunity there. Okay, going to the next slide. Did you have anything to add on any of these? Okay. All right, so moving on, and we've talked about this a little bit already, but what are some of the due diligence considerations when you're looking at either affiliating with a similarly situated entity, a joint venture, or opening up either a branch or a separate legal entity in Mexico, or frankly, any foreign jurisdiction? One of the first things that we always say is to have representation either from a consultant's point of view or resources that an organization like ISRI can provide, or legal counsel, either here or in Mexico, or frankly, in both jurisdictions. It's a great way to start to identify issues that you may not otherwise have considered. But in doing your due diligence, it's very helpful to look at the entity, look at their history, how long they've been in a particular type of commercial venture. They may be in your industry, in the scrap metal industry, but how long have they been actually undertaking manufacturing? How long have they actually had a distribution network? There are public resources both here in the U.S. and in Mexico that you can use that are free. The World Bank has some good resources that you can use, as well as some of the big accounting houses, PricewaterhouseCoopers, KPMG, et cetera, where you can look up entities and look up how long they've been in the business. As well, screening those entities against all of your U.S. lists to watch is what I call them. There are too many to name here today. But these are the lists that the U.S. government maintains regarding all sorts of different doing business requirements, so that, for example, one would be the U.S. economic sanctions list, where you are prohibited from doing business with entities and persons that are on such lists. The Commerce Department, on the other hand, maintains something called the BIS entity list. There, you may be able to do business with the entity, but you may have to get licenses to export certain types of materials. So looking at these due diligence requirements before jumping into any of these types of relationships, commercial relationships, is very important.
Can I just interject with one quick thing? One thing we're doing at ISRI is we're going to make some of these resources available. Our website is undergoing a renovation of sorts, and one of the things I hope to do is have some of that information. We've had a member run into a problem with that recently brought to my attention, that we just didn't have the information available ahead of time on these entity lists, and we will have that up very soon for our members to be able to access.
Great. And that's something it's an easy 5-minute due diligence step that can save a lot of cost, time, heartache later on in the game. And so we very much recommend it. And I would just add to that point as well, and we'll talk about this in a later slide, is to the extent that you are considering business opportunities that involve any subcontract or grant or federal funds, there are also public procurement lists and doing business lists that you'll want to screen, as well as the sort of regulatory compliance lists I'd put the others into. And so these public procurement lists are basically debarment lists, typically, for companies that have run into trouble in the execution of government contracts. So to the extent that you're looking to grow or sustain certain government contracting or federal funding work, you'd want to make sure that you also are screening those lists as well. And so country considerations, what to know. In Mexico, there are unbelievable opportunities. I'm a huge fan. I've done a ton of work there. But there are also challenges, and oftentimes those challenges are really based on where you're doing business. Mexico City, as many of you probably know already, is an extremely cosmopolitan place. Wonderful city. Most Major banking and financial institutions around the world have a presence there, which is very helpful for starting up a business there. But the regions in Mexico vary greatly. And so what may be true in a cosmopolitan city like Mexico City might not be the case in some of the more rural regions around the country that are often great regions to also consider for manufacturing operations. And so where in Mexico you're considering doing business is one of the first things to look at. That's from a geography point of view, from access to banking and financial systems, as well as crime and safety. And the cultural considerations that go along with this. The culture in Mexico varies greatly from place to place and is beautiful and unique in each one of those places, but brings with it certain business challenges. I've had a lot of opportunity to do business in some of the rural mountainous areas in Oaxaca, and there are language barriers. Frankly, many of the people there, even in the town and local governments, speak indigenous Spanish or indigenous languages that don't sound like Spanish at all, and very rarely speak English. Whereas in Mexico City, most business is conducted in English, or it's conducted in both Spanish and English, almost simultaneously. And so those are things to consider, weighing the opportunity of a more rural region versus some of the challenges you might face there. And so, that's number 3, the language. Number 4, the stability of your local government. The same case that I worked on that was in Oaxaca, we had not only federal government rules and regulations that we were dealing with, but we also had to look at what the local government rules, whether or not they had anything to do with the federal government rules, were. And we had to make sure that we worked with the local government, or else they weren't going to let us do what we wanted to do there, what our client wanted to do there. We wanted to be respectful of those rules and requirements, but also wanted to get business done. And there's sometimes a struggle there. But knowing ahead of time and looking into those issues is very helpful. I already mentioned the banking system. And then finally, the legal system, and I just mentioned this briefly. As I said, I'm the U.S. lawyer here, but the legal system in Mexico is a civil code system. Ours is a civil law system that looks at case law and precedent and evolving rules and regulations in state versus federal jurisdictions. Mexico has a federal civil code system, which is kind of like a set of regulations. And so understanding that is the legal system you're operating under. Case law is helpful and can be influential, but is not necessarily going to change the rules of the game. And so obtaining local counsel who has an expertise in either trade or in your industry specifically is really helpful to understand. Okay. All right, the next country consideration is looking at trade barriers or FTAs that might help you. Here, obviously, we have NAFTA. There are, in addition to the existence of NAFTA, which is the most famous, there are other potential restrictions that apply to trade. We call them there are a couple terms for them, but non-tariff trade barriers is often one that's used, and this is things like whether there are potential hindrances to movement of people or data over the border, and what you need to know about before. Do you need a license? Do you need permissions? In dealing with phytosanitary or anything that's regulated by the USDA, there may be additional requirements. We also have U.S. Customs as well as Mexican Customs often implementing what are called anti-dumping or countervailing duty cases, which would add additional customs tariffs to what you're doing, what trade you're doing, or could temporarily, for the course of that case, remove your good from NAFTA eligibility. And so those are things to consider as well. Will you be exporting? We talked a little bit about that. Despite Mexico being such a close neighbor, there are export controls, which really just mean license requirements on the export of many goods to Mexico. And then looking at the business sector, will you be conducting your business totally in the private sector in Mexico? Or is there public and private money that might be part of the business venture that you're looking at? Either regional Mexican government money or federal Mexican government money. And that can really change the dynamic of who you're doing business with and how you're doing business. There's a law that's coming on the books in Mexico in July of 2017 that deals with administrative procurement and public procurement rules. And that'll be very important to consider if any of the work you're looking at involves public infrastructure in Mexico and the interaction with public officials. And then finally, as we mentioned earlier, the use of in-bond processing companies that are commonly known as Maquiladoras. And for those of you who are not familiar, these are typically wholly foreign-owned entities, and they enter into contracts with U.S. companies, allowing the U.S. company to oftentimes supply materials like large machinery in order to further process or semi-finish goods and products, which is done there. They're kept in bond, which means they're not, the products, the material sent down to Mexico is not formally entered into the Mexican customs territory, and then shipped back in that semi-finished state to the United States, again, in bond. In doing so and utilizing the Maquiladora process, you don't pay any tariffs or duties inbound into Mexico or back inbound into the United States, generally speaking. As I said, this is a fact-specific analysis, but one that's very, very helpful to companies looking to take advantage of the labor market in Mexico, which is generally very beneficial and lower cost than that of the United States. One thing to consider, however, in using the Maquiladora system is that whatever you're sending, it's still an export. While taxes and duties may not accrue, you're still enacting a legal export of whatever it is that you're sending, and there may be licensing requirements and considerations. Okay, I think much of the rest of the slide we've touched on. Okay. All right, so the next thing, we've talked about all of the due diligence and opportunities in looking at local partners in Mexico. When it comes to putting the rubber on the road, getting a contract in place, an agreement, a memorandum of understanding, what you call it may vary, even maybe a charter or a chapter agreement with a local entity that you want to bring into the fold, but not quite make a branch of your U.S. headquarters. What does your contract say? And what would we recommend that it say? As we said, it's often easier to get into these relationships than it is to get back out of them. And so it's careful review of any of these agreements is key. First, as we noted on the earlier slide, most business truly is conducted in English in Mexico. Knowledge of Spanish and understanding the language is a huge advantage, and one that if you can take advantage of that resource within your company, we would absolutely recommend doing so. But we would recommend from a U.S. legal point of view that your agreement is in English. And then a few sticky provisions that we often see being sort of the height of the negotiations between the U.S. entity and the foreign entity in Mexico or elsewhere would be the following. The first is your dispute resolution clause. And this is your controversy clause. What happens if there is a contract dispute, there is a dispute with you and your agent or the entity that you formed that may be a branch or your JV partner? Do you first go to arbitration? Do you go directly to litigation? What is the forum? What is the type of dispute resolution that you will use? Outside the United States, in my experience, I've found that very few countries go directly to litigation like we do. That is the court system. And that's, in my experience, also held true for Mexico. And so we often see dispute resolution clauses that sort of gain momentum, if you will. They may go to arbitration first. They may start even internally with a moderator or a mediator, then go to arbitration, and then ultimately go to the court system. This is recommended so long as there are clear, concise time frames on the escalation of the dispute resolution, so that you, the U.S. entity, the investor, are not just sort of left with your hands tied and sort of an ongoing open-ended dispute. If the ultimate provision ends up being arbitration, We would also recommend considering carefully the arbitration body that ultimately governs here. There are internationally recognized arbitration bodies, and then there are local arbitration bodies in almost every country around the world. We would recommend using the rules of the ICC, the International Chamber of Commerce, or one of the other internationally recognized arbitration bodies so that you are better able to enforce any ultimate dispute resolution that is reached between you and your partner or you and the entity that you're working with in Mexico. In your governing law provision, the ultimate goal is U.S. is the governing law. Your state, the United States. I can tell you that that's often a challenging provision to enforce. We always go in with that as sort of our first go around, with the understanding that if the entirety of the activities are going to be taking place in Mexico, you're probably going to get some pushback on that. And again, then we go back to, well, let's make sure our dispute resolution clause is tight and clear. But starting with U.S. is something that we'd always recommend. Oftentimes, although it may seem like, every conversation you've had, every email you've had is in English, it's very recommended to also put it in the contract that your business deals, that your dispute resolution will be in English, just to make clear that should something go on down the road, that it's in English, and that's to protect you, the U.S. entity. Making sure that you have language in the contract that if you are working with a consultant or a distributor or an agent, that makes clear he is an independent contractor. Now, I will also say this is a U.S. law protection. This is a U.S. legal consideration. We have very clear laws and case law that can support who is an independent contractor versus who is an employee or an agent that's closer to an employee under U.S. law. Every country around the world, however, has different laws that govern employees, and Mexico included are often very pro-employee. So I would say including language in there that ensures, that the person or the entity is an independent contractor is important, that your relationship is one of independent contractors is important, but you may still find that there are some challenges under Mexican law in the interpretation of that if something should come back regarding an employee or a contractor working with you. We'll talk a little bit more detail about IP, but ensuring there is clear, concise, firm intellectual property and copyright language in your contract is highly recommended. And to include in there, we often call confidential information or business proprietary information, which may not be, your marks or your other IP, but is nonetheless very important to your brand and your company. And finally, make sure there are clear termination provisions. How to terminate, when the contract can be terminated, and for what reasons. Okay, so we'll go through the IP slide quickly. There's a lot of information on there. But I would say this is really broken out into intellectual property. It's 3 categories at the top, but I'll call it 4. You have your logos, your trademarks, your patents, and then your business proprietary or confidential information. We want to make sure from a U.S. legal perspective you're protecting all of it when you're looking to do business in Mexico. Doing business in any foreign jurisdiction presents challenges and potential risks to your intellectual property. Mexico is a first-to-file country, generally speaking. That means the first person to file, from a trademark perspective, to file your marks has rights to them. However, very much like the United States, there are certain challenge provisions where if there has been commercial use of your marks in Mexico, there can be some back and forth. And there is case law to support a challenge to someone who's already filed your marks. We don't want you to get to that point. But knowing the jurisdiction and knowing that Mexico is a first-to-file jurisdiction is important, and it's an important due diligence step before you go in. So, is your IP registered here in the U.S.? Do you have rights to it in the United States? That's number 1. Number 2, have you ever done business outside the United States before? And if you have, do you have oftentimes companies will do almost a foreign version of their US IP. It may be that the name of the company is in Spanish instead of in English, or the logo is slightly changed to include the word Mexico. That can be a good way to protect your US brand and establish sort of a footprint in the foreign jurisdiction here in Mexico. And if you do so, we would also recommend looking into filing that brand, that trademark in Mexico. And as we just noted, making sure you're differentiating between the different types of IP in your contract or agreement, as well as getting it in there clearly. Defining what's your IP, what's the scope of your confidential information that you want to protect. It could be, we have one entity that insists that their mailing list and the phone numbers on it is actually IP. I would call it confidential or business proprietary information probably, but nonetheless, it is defined as part of their IP in every one of their agreements with an overseas entity. That's a first line of defense to ensure that you're protecting what you've built up here in the United States when you go into another jurisdiction. U.S. trademark registration is ineffective in foreign countries. So just because you may be registered here does not mean that you're protected elsewhere. Almost every country in the world has a little bit of a difference in the way that they protect and require IP to be registered and used. And so if you're looking at Mexico, but you're also looking at Brazil, and you're also looking at China or India, it's a country-by-country analysis in each of those jurisdictions. And then in the last sets of bullets, we're looking at some best practices. I would say that creating internal controls first before going into a foreign jurisdiction, ensuring that you have protocols, you're going out and you're establishing a new branch or entity here in the US, they should be the same protocols that apply when you go abroad, when you go into that foreign jurisdiction. Taking those affirmative steps to protect your brand. And retaining express control over it, having it in writing. Don't assume that the goodwill of your partners is going to mean that they don't say, oh, look, I can hold myself out as, the ISRI company here in Mexico. And we'd already talked about creating a foreign section or a foreign version of your brand. Insurance and in-company employment considerations. We'll go through these, at a very high level because this is very fact-specific. But before going abroad, we always would recommend taking a survey of your insurance coverage. Would it apply to your own U.S. employees going down and working at, even a couple days, a month, or a couple times a year at an entity in Mexico, or at a trade show or networking event in Mexico, or with a distributor? Do you have to go back to the insurance companies and ensure that there is coverage, not only for U.S. employees going down, but also for anyone that you may hire? Or is there a better way under Mexican law to secure coverage for someone you might be working with there? Oftentimes the answer to that question is yes, but exploring that on a case-by-case basis is recommended. And then again, we talked about treatment of in-country employees. Very pro-employee countries throughout Central America. And so we would recommend looking at the way that an independent contractor, quote unquote, or an employee would be treated there, what type of additional benefits they should be entitled to or would be entitled to depending on how they're characterized. For example, there's an equivalent of like a Social Security payment that is applicable in Mexico. Depending on the characterization of the person working for your entity, should you be paying into that? Are there healthcare benefits that you should be paying into? Is there a certain amount of days, requirement that triggers those types of considerations? And obtaining local counsel to make those determinations for you saves a lot of headache down the road when there may be a whistleblower or an independent contractor who comes back to you and says, you actually owe me 3 years of X payment. And there may be penalties that also accrue. Okay. And doing, as we keep saying, I think it's kind of the mantra here, background and due diligence on whomever it is that you will be working with in Mexico is very important. All right. So, tax and accounting issues. I always think of this slide as two big chunks. The first is, what are your U.S. obligations? And the second is, what are your Mexican obligations? Depending on the level of activity you have in the foreign jurisdiction, what your obligations are under Mexican law are going to vary. And to an extent, what your obligations are under U.S. law may vary as well. Under U.S. law, reporting the income, making sure that you're looking at whether the entity is disregarded, whether it's flowing up to the U.S. headquarter entity, how your accounting books are showing the activity of that Mexican entity is extremely important. There may also be, and I'm skipping to the final bullet here, foreign financial bank account filings, we call them FBAR filings, that may also begin to be required for your U.S. entity. These apply where you may establish an entity in a foreign jurisdiction, here in Mexico, and there's a bank account that is active. If the bank account hits certain thresholds, one big one is $10,000 US dollars. There are certain FBAR filings, which are largely informational filings that have to be made with the IRS. However, when they're not made, and they're fairly simplistic when you consider the tax code at large, which I also hear is being reformed today, the obligation and the penalties accrued over the years can be onerous, and you want to avoid that. And so looking at as well, what are the audit standards? This is another big one that comes up in many, many of the conversations I have with our clients. In the United States, we have the GAAP, Generally Accepted Accounting Principles. In Mexico, it is the Mexican Financial Reporting Standards, or the MFRS. The MFRS are similar in a lot of ways to the GAAP. And oftentimes, in working with tax authorities, the Mexican customs is actually under their tax authorities. We see Mexican tax authorities looking to the GAAP to sort of fill in blanks in the way that accounting standards and principles are accepted there. However, the MFRS do differ from the GAAP in some important ways, specifically on movement of goods over the border, as well as provision of services. And so looking to find a local accountant is recommended. Okay. I think we can move on from that slide. All right, so other U.S. legal considerations. So putting back on my sort of export controls hat, my inbound and outbound hat, this is a lot of the questions I deal with day in and day out with all kinds of U.S. companies. And you find that oftentimes companies say, well, I was carrying my computer down with me for a networking event, or I was carrying some audiovisual equipment with me for a one-time conference. It's not just their products that they're worried about. But all of a sudden I realized there was an export control or licensing requirement that may have applied. And so what we would recommend is always looking at what you're sending, what you're exporting, what's your product. Is it a raw material? What is in your raw material? There are certain scrap metals that are covered by what's called the Export Administration Regulations. Those are enforced by the Commerce Department, and they apply to all sorts of commercial or dual-use goods. And depending on the content of your metal, your products, there may be some that apply to exports of that product to Mexico. It's a very fact-specific analysis, and we will not go into it and bore you with it today, but it's one to consider. Certain scrap metals as well that are scrap from munitions also might be controlled by what's called the ITAR, or the International Traffic in Arms Regulations. This is less and less the case, but there are ITAR licensing requirements on exports to Mexico as well. So knowing what your product is, and in addition to your actual physical product, any technology or technical information that may go with it that you're sending down to Mexico, and that export could be hitting the send button on a computer, is extremely important to understand before you export. This is all prior to export. In addition, if you are taking any sort of equipment, audiovisual, satellite phones, computers to Mexico, there may be requirements on exporting those as well. There also may be exceptions to that, but knowing before you go is recommended. And then, are there sanctions? There are not sanctions on Mexico like there are on Iran or Syria or North Korea. However, there are certain designated persons and entities in Mexico, such as under what are called the kingpin designations or the specially designated global terrorist designations. These are all maintained by the Treasury Department and specifically a group called the Office of Foreign Asset Controls. So screening, like we talked about earlier, and making sure that you're not doing business with one of these people is a first and foremost priority. And then finally, on the inbound side, how is your transaction structured? Looking at what are called Incoterms, these are globally recognized transactional terms that determine who is paying customs duties, who is paying freight and insurance. How is your transaction inbound into the United States structured, and who is responsible for what? Knowing that and knowing ahead of time so that you can build it into any bills of lading or service contracts that you may be using with a particular partner can be beneficial to you and your business. As well as understanding NAFTA, just bottom line, do your goods qualify? Are there exceptions that you can use? What analysis should you be using to determine that? And with that, we'll go to NAFTA, and this slide is called NAFTA Renegotiation, and I'll let Adina talk a little bit now and stop boring you with my voice.
No, you're fine. Thank you, Carrie. I'm just going to talk just for a minute or two since I've been talking on this topic, with our membership for the last few days. Here's what we know about the Trump administration sort of direction on NAFTA. We're not 100% sure. We saw a draft letter to the Congress a few weeks ago that told us that they're not looking at that they were not considering a wholesale scrapping and renegotiation of the agreement, that maybe they would just modernize the agreement. However, in a speech last week in Wisconsin, President Trump said, no, it's a terrible agreement, we're going to get rid of it. So we're still trying to sort through, and I think even he's trying to sort through what might be best for businesses and best for the economy. But what we do know is, in his trade policy as a whole, he's looking to create jobs and economic opportunity. And he wants to do that through defending U.S. sovereignty, enforcing U.S. trade laws, and using whatever leverage is out there to, of course, open markets. So in the NAFTA, certain critical issues, some of them listed here, I'll just touch on a couple that I think are critical for recyclers, is the rules of origin provision. So, we know that, or we hope that they will take into consideration modern supply chains and also protect the efficiencies and economies of scale that were created by the agreement in the first place. Secondly, of course, is enhancing market access opportunities, and sometimes that includes what we call regulatory harmonization, which is to say there could be a regulatory piece in one country, dealing with something having to do, just to throw out an example, environmental protection of some sort. They each have a regulation, but they look a little bit different. Would one country be willing to recognize that a company meets the specifications of the regulation in the other country? And also standards and specifications. So will, Mexico be willing to accept ISRI specs, for example, if U.S. law accepts that as well. And then, of course, improving just the efficiency of our borders, just allowing the movement of material and people and equipment across borders, making sure there's no bottlenecks and all that. And, of course, we at ISRI, we're looking at NAFTA from also what's happening north of the United States as well, the opportunities in Canada. And so in that space, we are just getting started on creating a common advocacy platform that we can work with the Canadian Association for Recycling Industry, CARI, which is our Canadian counterpart, and also some Mexican partners to promote and advocate for what we think has gone right with NAFTA, and maybe creating new opportunities through whatever iteration of the negotiation will take place, and we can do it together. Just timing-wise, we did learned yesterday that the U.S. Trade Representative designate, Robert Lighthizer, was voted out of committee. And so he will face a Senate confirmation vote, hopefully sometime in the next week or two. What that means for NAFTA is that the administration is appropriately waiting until he's in office, until they decide to move forward. And as Carrie mentioned early on in her speech, we saw this morning that they are working on the executive order that would kick off the reporting requirement to the Congress that says they're interested in renegotiating. It's a funky legal term through the U.S. Trade Promotion Authority, but they're waiting until Ambassador Lighthizer is in office for that to take place. So hopefully within the next couple of weeks. But timing of the NAFTA negotiation itself, whatever iteration it takes, we hear in the press that they want to get it done by the end of the year. It's not going to get it done by the end of the year. A negotiation is a give or take. All parties have to come to the table. We know that. There's going to be great opportunities, we hope. Once we know what that's going to look like, it'll be opportunities for us to speak up. But if I had a crystal ball, I would say it'll probably be at least 2 to 4 years until we see whatever the new structure is going to be. I'm going to turn it back over to Carrie.
I 100% agree with you. 2017 is not the year of NAFTA, a new NAFTA. We'll talk about it for the rest of 2017, though, I'm sure. I think that one thing I would just add there, in considering the fact that it is really status quo still today, is that a huge focus on trade under this administration has been enforcement by U.S. Customs. And, putting that into context, that means ensuring that if you are utilizing any free trade agreement, and first and foremost NAFTA, that you do have your ducks in a row and you're utilizing it correctly, you are properly determining rules of origin, you are obtaining the proper documents underlying any claims that you make, is really important these days. We have clients in every industry, you name it, that are getting what are called CF-28s and 29s from U.S. Customs, which are requests for information and rate advances that are in relation to use of free trade agreements right now, especially in industries where there are also anti-dumping and countervailing duty cases, such as the steel industry, for example. And so we see a lot of additional internal compliance requirements and just more of a robust reaction that companies are having to make to customs in order to sort of verify that they're properly using the free trade agreements or they're properly importing their goods. And so, whether NAFTA changes or not, an executive order issued March 31st said that Trump is putting even more resources on this topic, and we expect that trend to continue. And so making sure that, internally your companies are assessing this issue and really understanding what the obligations are when you're importing goods is a priority.
And that includes, of course, if there's anything of interest to you, whether in the current structure or any worries about a future structure, you can certainly let us know. That would become a part of our advocacy strategy. I want to allow for Q&As.
Yeah. Okay. So let's see. I'll just touch briefly on anti-corruption. The U.S. has a law called the Foreign Corrupt Practices Act, the FCPA, which says that you can't bribe a public official. And you can't bribe them with anything, not just money, anything of value. So the promise of a future contract, et cetera, it's not just pushing the briefcase of money under the table like you see in the old mafia movies. This law has been extremely broadly interpreted. And so we've seen it go all the way down to like a customs official at the border, being considered a foreign government official. The U.S. used to be the only player in this game. This law has been on the books since the 70s. But in the last 5 to 7 years, we've really seen an uptick by other jurisdictions in enforcing compliance with anti-bribery provisions. Mexico, actually in July 2016, initiated what's called the National Anti-Corruption System, which was the largest scale integration of all of their local, regional, and federal government basically initiatives on anti-corruption. Mexico's law, even though the U.S. is often pinged with, being the big stick around the world on the FCPA, actually includes not just what we call public bribery, but also private. So, and interestingly, in part of the law that doesn't come into effect till July of this year, July of 2017, Mexico's law says that an affirmative defense to being brought up on bribery charges in Mexico is if your company has a robust, basically, they call it an integrity policy, but an anti-bribery policy in place. That's a first line of defense under the U.S. law as well. In the interest of time, I won't go further into that, but if you have any questions regarding the FCPA or what kind of compliance policy is appropriate for your business, because it's not one size fits all. It's a very important consideration when you start going abroad and having to interact and get permits or interact with officials to understand authorizations, and making sure that you protect yourself in that way. Okay, so I have two quick case studies. The first is what we sort of just talked about, which is the use of NAFTA. We were representing a U.S. company that on a regular basis, I mean, they understood NAFTA. They got it. They had been using NAFTA for 10 years. They had internal policies, or so they thought. And they had also set themselves up to be a non-resident importer in Mexico, which means that they didn't have an actual an actual legal entity in Mexico, but they were the legal importer of their goods. They paid the duties if they had to, if they applied. Otherwise, they imported the goods and immediately handed them off to distributors. That meant that from the Mexican government side, they were an importer. They were an importer using NAFTA. So Mexico, the Mexican Customs Authority, sent them what's called a verification request, which is a request for documentation supporting your NAFTA claims. This is also a requirement on the U.S. side, and to Adina's point on regulatory harmonization, the law looks a little different under the U.S. side of NAFTA and the Mexican side of NAFTA, which is a bit tricky and frankly annoying. So this U.S. company gets the verification request from the Mexican Customs Authority, and it sits on somebody's desk. It sat there for, I don't know, maybe a week or two. They passed it on to somebody else. They figured they weren't the person. They didn't know what a verification was. It went on to somebody else. About 40 days later, they received a notice that said, you didn't respond to our verification request within 30 days. It's now no longer timely, and you owe us about $3.5 million in duties, which was great. They all freaked out. And that led to a 3-year legal battle. It was a very interesting one because it ended up that in this instance, the Mexican Customs had served the verification request improperly. In other words, their mode of service. You hear under U.S. laws, you have to be served a certain way in order to have to appear at court if you get a subpoena or something like that. The same is true under NAFTA. And they just used normal Mexican mail, just the Mexican Postal Service, which was not proper service under Mexican law, and we won the case. But then we turned around to our client and we said, if you ever get one of these again, open the envelope and look at what's inside. And make sure, from the U.S. side as well as the Mexican side, that you have the documentation supporting your NAFTA claim. Those of you in the room that have never used NAFTA before know that submitting a NAFTA certification, a NAFTA certificate, is just a 2-page document. But in utilizing the agreement, what you are formally attesting to the government, either the U.S. or the Mexican government or the Canadian government, is that you have the documents that show that your goods qualify. And so the lessons learned here were really the benefits and challenges of NAFTA and understanding NAFTA, what a verification is, what the process really means, and having internal company controls that make sure that you have these documents. There's a requirement you have to have them for 5 years. That statute of limitations goes back, and if they ask you for some import from 5 years ago, you are expected to have those documents. We utilized fantastic Mexican Trade Council. Utilizing local expertise is really important in these matters. And understanding the laws where you're working. It was a civil law country. We had to understand that and understand how that differed from the way the case was being handled on the U.S. side. The next example I have is one that just involved more general regulatory compliance. This was a company based out of California, and they had a large-scale research, data, people-heavy initiative going on in Mexico. It was going on in several different areas. This was the case I talked about earlier, which involved Oaxaca. It also involved some areas on the East Coast and people in Mexico City. They were working with universities. They thought, well, we're working with universities. These are owned by the government. We must be doing everything right. They were sending things down, bringing them back. The product and technology and people all required authorizations and permits, both on the Mexican side and the U.S. side. This didn't have anything to do with NAFTA either. This wasn't about customs duties and taxes and all of that. But frankly, they just didn't get the permits ahead of time. And I think in 2012, I started helping this company out, and we are still waiting for the final okay from the Mexican government, where we said, look, we went backwards and we fixed everything. We meant to be a good corporate citizen, and we just didn't understand the rules. And they finally said, okay, we agree. But we're still waiting for that stamp of approval. And so this company had hooked up with a JV partner in Mexico that had a much different, I think, ultimate goal than the U.S. company did. And there were a lot of business struggles that went through this whole case. And so understanding who your partners are, doing due diligence on the permits required ahead of time saves so much time and money down the road. And I can talk more to it if you have specific questions, if this sounds familiar, but it's something to keep in mind.
Carrie, thank you so much. I always have many questions, but I'd like to offer folks here to speak up with anything you may want to get answered. And if you can project your voice, you can stay where you're seated, or else there's a microphone in the aisle if anybody has any questions. And if not, then I'll ask mine. Questions? Okay, so I have a couple of questions, but we'll make it really quickly. You mentioned security at one point in your remarks. Can you elaborate on that a little bit? Because it is a major concern, actually, I have heard from some of our members about it, both personal security as well as for the security of their materials as they move down into Mexico. Mm-hmm. How should companies work to minimize these risks?
That's a great question. I'll start with personal security first. And this is really where it becomes very important to partner with someone, I think in the due diligence stages, a consultant or legal expert down in Mexico, or even someone at an entity similarly situated to yours. So that you have a local contact. I think that in my experience, and I think one year I went to Mexico like 6 or 7 times, making sure I was with someone locally integrated there, in Mexico City or wherever it is that you're traveling, is just a great first step. And then I think this sounds a little bit, in the weeds, but I think also never getting into a taxi in Mexico City is a good idea. Hiring personal cars for the week or however long you're there, or having the person that you're working with locally, their driver or something like that. It's just, I think, a good first step. When you get out, Mexico City, on the other hand, is an extremely cosmopolitan city. It's beautiful. There are neighborhoods where you feel like you're in Europe, and there's really not very much of a safety risk outside of the kind that you would just tell any tourist in any European country. But outside of Mexico, I think it's really important to understand where you're going. The region of Oaxaca, for example, and some of the northern Mexican towns where I've been, to some of the Maquiladoras, again, making sure you hire a safe driver, car, and someone who knows where they're going. And then you're really fine, so long as you're not just sort of using Google Maps and perhaps taking a wrong turn. But I think that's on the personal side. On the product side, working with a trusted logistics broker, I think is the answer there. There are so many brokers, logistics companies in the United States, but there are a few that have legitimate, we call it southern border expertise, and identifying one of those, and I have some recommendations if anyone's looking, and working. Oftentimes these U.S. companies have bought local brokers on both sides of the border. And so it's, ABC Co. on the U.S. side, and it's also ABC Co. on the Mexican side. And it's efficient for them, but it's also safe for you. And so that's what I would recommend on the product side.